Today on Legalese, we are talking about Culley v. Marshall and the beginning of the end of civil asset forfeiture. Hey, greetings everybody, and welcome back once again to Legalese. As always, I'm your host, Bob, and I want to thank you all so much for joining me here today. Now, if you happen to be new to my channel, let me especially welcome you. This is a podcast where we're going to be discussing all things constitutional law, as well as current events in other areas of law, politics, and culture. Now, I just want to remind you guys real quick, if you want to find out more about our show, you can go check out our homepage over at legalesepodcast.com. And if you want to get up-to-date notifications whenever I post any new content, and I don't just do videos on YouTube, I post these to alternative platforms. There's an audio-only version of the show. I write articles over on Substack, and if you want to get notifications for all of those things or some of those things, either way, all you have to do is head on over to legaleseshow.com where you can subscribe to our newsletter and get notifications sent right to you. All right, well, as always, we got a lot to get to today, so let's just fucking jump on in here, shall we? Now, recently, the Supreme Court would issue its opinion in the civil asset forfeiture case of Culley v. Marshall. That, as this case is being covered by those who are critical of the practice of civil asset forfeiture, which is most of the coverage because, in fact, studies show that 84% of Americans oppose civil asset forfeiture as a practice entirely. And those who do oppose it are covering this case as a losing case on this issue, which on its face is kind of true. But the thing is, as soon as you dig past the surface level, this decision actually has a lot to get excited about. Now, this video is not going to be my normal comprehensive case breakdown like I would normally do with a like my Supreme Court round of videos because frankly, the majority opinion of this case is not one I'm especially interested in talking about. Though that's not to say it isn't an interesting or important case. It is. And so I will be linking to the majority opinion on the show notes page, as well as several really good articles that do give a comprehensive breakdown on the case. And I do encourage everyone to go and read those for themselves. I just won't be giving that kind of comprehensive breakdown here today. Now, on the surface, this decision was really nothing more than a procedural issue about what constitutes a timely forfeiture hearing under the Due Process Clause and only dealt with a split in the lower courts, specifically as to whether they should apply a four-part legal test in accordance with the Barker and $8,850 cash precedent, or the three-part test set forth in the Eldridge precedent. And by a vote of 6-3, the court would choose the former, the Barker and $8,850 cash test. Now, what makes this case so interesting is that when we read the three-judge dissent, which was authored by Justice Sonia Sotomayor and joined by Justices Kagan and Jackson, along with the two-judge concurrence authored by Justice Neil Gorsuch and joined by Justice Thomas, what we find is there is a 5-judge majority on the court in favor of a broad and sweeping civil asset forfeiture reform that is ready and willing to declare that any move by the government to seize assets would require a jury trial prior to seizing those assets. Now, this would finally bring civil asset forfeiture fully into conformity with the Constitution's 5th and 14th Amendments due process clauses. And in fact, in Justice Gorsuch's concurring opinion, he virtually invites litigants to bring a broad challenge, arguing all civil asset forfeiture requires a prior jury trial before seizure, and such a case would spell the end of unconstitutional civil asset forfeiture nationwide, with the same kind of sweeping reform that we saw in last year's Tyler v. Hennepin County, which put an end to the practice of home equity theft. And so it is the potential for this broad and sweeping reform that I want to talk about with you guys here today. Now, before we get into the main discussion of this case, there are some common criticisms I have been seeing from articles written by corporate media on this case, as well as from people who are clearly just relying on those same sorts of articles to criticize the case. Um, and the shallow articles I'm talking about are really typified by an article posted by Jordan Rubin over on MSNBC called "The Supreme Court Says Cops Can Keep Your Stuff Pending Forfeiture Hearings," which will be linked on the show notes page. Now, in his article, he says that the Supreme Court's Republican adjoint appointed majority, yet again, went further than it had to. This time, the court approved stingy safeguards for civil forfeiture proceedings when law enforcement takes your personal property, such as a car that is allegedly tied to a crime, even if you are innocent. And led by Justice Brett Kavanaugh, the majority said Thursday that while timely forfeiture hearings are required, the Constitution doesn't require a preliminary hearing to determine whether police can keep your property pending such a hearing. And in declining to grant that minimal safeguard, Justice Sonia Sotomayor wrote in her dissent that the majority sweeps far more broadly than the narrow question presented and hamstrings lower courts from addressing myriad abuses of the civil forfeiture system. Now, this sort of focus on headline issues is leading many people to claim that what Justice Sotomayor was saying is that the court should have simply ruled that under due process people are entitled to a prior civil forfeiture hearing, and because they didn't decide the case that way, their application of a judicial test that does not simply declare that people have the right to a prior civil asset forfeiture hearing, the court went beyond the question they were being asked to decide in this case. Now, the other criticism I have been hearing is that since Justice Gorsuch and Justice Thomas generally take a more, what many people are calling a more libertarian, hardline approach to property rights, including civil asset forfeiture, that they're joining the majority with them demonstrating they don't actually care about civil asset forfeiture, nor do they really believe in the protection of property rights when it's inconvenient to them. Otherwise, the argument goes they would have dissented and simply held that in this case, the civil asset forfeiture requires a prior hearing. Now, both of these arguments are incorrect for the same reason. That is because both arguments go well beyond the question presented the court was asked to decide. So, turning to the question presented in Culley v. Marshall, what the court was asked to decide was, in determining whether the due process clause requires a state or local government to provide a post-seizure probable cause hearing prior to a statutory judicial forfeiture proceeding, and if so, when such a hearing must take place. Should district courts apply the speedy trial test employed in the United States v. $8,850 cash and Barker v. Wingo, as held by the 11th Circuit, or the three-part due process analysis set forth in Matthews v. Eldridge, as held by at least the 2nd, 5th, 7th, and 9th Circuits? Now, while it is true that in the lower courts, this case did involve people whose property has been seized asking for a prior hearing in accordance with the Due Process Clause. As we just saw in the question presented, that is simply not the case that came before the court. Here, the court was only being asked to resolve the circuit split between applicable precedents, and neither precedent actually called for a prior hearing in forfeiture cases. And in fact, if you keep reading, that's not even what Justice Sonia Sotomayor's dissent is arguing for. So what she says is that she would have decided only which of these due process tests governs whether a retention hearing is required and left it to the lower courts to apply that test to different civil forfeiture schemes. So what she is saying is that the court was more specific about how particular precedent they said should control should be applied. Indeed, if the concurring or dissenting opinions in this case would have argued that the court should have ruled in Culley that all asset forfeiture requires a prior hearing, it would have been those dissenting and concurring opinions that were reaching far beyond the scope of the case before them. So, with that hopefully cleared up, let's get into the case itself. Now, while, as I said in the beginning, this case will not be the kind of comprehensive breakdown that I often do, it obviously does require a basic understanding of the case. So let's do a very brief review of the facts of the case and the majority opinion penned by Justice Kavanaugh. In Culley v. Marshall, the Supreme Court reached a decision that the seizure of property through civil forfeiture requires a timely hearing, though it does not require a separate preliminary hearing to determine whether the police may retain the car pending the forfeiture hearing. Now, the justices would split 6-3 along ideological lines. However, the concurring opinion by Justices Neil Gorsuch, that was joined by Justice Thomas, suggests that there may be a majority in favor of a more fundamental challenge to the abusive asset forfeiture regime that still exists in most states. Now, civil asset forfeiture is a process that enables the government to seize property that has allegedly been used in the commission of a crime. Even if the owner has never been charged or convicted of anything, and in many states, including Alabama, whose policies were at issue in Culley, law enforcement can then hold on to the property for many months before the owner is allowed to contest the seizure. Moreover, many states allow law enforcement to keep the proceeds from seized property, thereby creating an incentive to take as much as possible. Now, Culley will involve two Alabama cases where the owners of cars were subject to asset forfeiture as a result of the use of the vehicles by other people to conduct illegal drug transactions. The owners eventually did manage to prevail in state court, but that process took many months, and in the meantime, they were deprived of their vehicles without any compensation. Now, critics have long argued that such practices violate the due process clauses of the Fifth and 14th Amendments, which bar the government from depriving any person of life, liberty, or property without due process of law if the police can seize property and hold it for months on end without any meaningful process at all. Then surely we do not have due process of law. Now, in the majority opinion, which was written by Justice Brett Kavanaugh, the Supreme Court would nonetheless rule that a separate preliminary hearing is not required in such cases for two reasons. First, they contend that this issue was already resolved in two earlier Supreme Court precedents. So, Justice Kavanaugh says, ultimately, we need not reweigh the competing due process arguments advanced by the parties because the court's decision in United States v. $8,850 cash and United States v. von Neumann already resolved the issue. After a state seizes and seeks civil forfeiture on personal property, due process requires a timely forfeiture hearing but does not require a separate preliminary hearing. And the dispute in $8,850 cash arose when Customs Services seized currency from an individual entering the United States, but then waited before filing for civil forfeiture of the currency. The property owner argued that the delay violated due process. This court concluded that a post-seizure delay may become so prolonged that the dispossessed property owner has been deprived of a meaningful hearing at a meaningful time. The court elaborated that timeliness in civil forfeiture cases must be assessed by analogizing to a defendant's right to a speedy trial and considering four factors: the length of the delay, the reason for the delay, whether the property owner asserted his rights, and whether the delay was prejudicial. Those factors are appropriate guides in the civil forfeiture context, and the court explained because the factors ensure the flexible requirements of due process have been met. And in von Neumann, the court addressed whether a timely forfeiture hearing without more provides the process that is due in civil forfeiture cases. The property owner there failed to declare the purchase of his new car upon driving it into the United States. A custom official determined that the car was subject to civil forfeiture and seized it. The plaintiff filed a petition for remission of the forfeiture, in essence, a request under federal law that the federal government exercise its discretion to forgive the forfeiture. The government did not respond to the petition for 36 days. The plaintiff sued, arguing that the government's 36-day delay in answering the remission petition violated due process, and Justice Brennan's opinion for the court broadly held that due process did not require a pre-forfeiture hearing remission procedure in the first place. And the court's decision in $8,850 cash and von Neumann resolved this case. As the court stated in von Neumann, a timely forfeiture hearing satisfies any due process right with respect to a car that has been seized for civil forfeiture. The due process clause does not require a separate preliminary hearing. Now, the second reason why the majority would reject the need for a pre forfeiture hearing was a flawed analysis of the originalist text, history, and tradition standard. So, back to Kavanaugh's majority opinion, they say historical practice reinforces the holdings of $8,850 cash and von Neumann that due process does not require preliminary hearings in civil forfeiture cases. Since the founding era, statutes have authorized the government to seize personal property and hold it pending a forfeiture hearing without a separate preliminary hearing. For example, the first federal forfeiture law, the Collections Act of 1789, authorized the civil forfeiture of ships, goods, and merchandise involved in suspected violations of the customs laws. The collector then filed a forfeiture action, which a court would hear and determine according to law. While that action was pending, the seized property could remain in the custody of the collector. The Collections Act did not require a separate preliminary hearing before the forfeiture hearing. Rather, the forfeiture trial supplied the opportunity for the property owner to challenge the collector's case. Now, in his very forceful concurring opinion that reads in most ways much more like a dissent, Justice Neil Gorsuch would outline serious due process flaws in the current asset forfeiture regime, and in the process, he would undermine the majority's arguments. And he would undermine both their arguments based on case precedent as well as their originalist analysis. Now, like Justice Sonia Sotomayor in her dissent for the three liberal justices, Justice Neil Gorsuch would emphasize the abusive practices of the modern asset forfeiture regime and the fact that most of it is of relatively recent origin, arising from the growth of the war on drugs. And this, he says, puts it in serious tension with the text and the original meaning of the Constitution. So, turning to his concurring opinion, he says, to my mind, the due process questions surrounding these relatively new civil forfeiture practices are many. Start with the most fundamental one. The Fifth and 14th Amendments guarantees that no government in this country may take life, liberty, or property without due process of law. As originally understood, this promise usually meant that a government seeking to deprive an individual of her property could do so only after a trial before a jury in which it, not the individual, bore the burden of proof. So, how is it, he asks, that in civil forfeiture, the government may confiscate property first and provide process later? The answer, if there is one, turns on history. If, as a rule, the due process clauses required governments to conduct a trial before taking property, some exceptions are just as deeply rooted. And for just that reason, these exceptions, too, may be consistent with the original meaning of the Fifth and the 14th Amendments. Now, Gorsuch goes on to note that the founding era and Supreme Court precedents cited by the majority may not be generally applicable because they arose in the discrete arenas of admiralty, customs, and revenue law. Now, that is certainly true of the Collections Act, and it is also true of the precedents in $8,850 cash and von Neumann, the two modern precedents emphasized by Kavanaugh. But as Justice Gorsuch points out, these areas are likely to be special cases that are exceptions to the general rule that the government may only seize property after a trial. So, returning to Gorsuch's concurring opinion, he says the reasons for the law's traditionally permissive attitude towards civil forfeiture in those three contexts may merit exploration too. And he means in accordance with the Collections Act and the precedents in 8,850 and von Neumann. And so he says, from a brief look, it seems they were sometimes justified for reasons particular to their fields. In the early republic, for example, once a ship involved in violations of the nation's piracy or customs laws slipped port for a foreign destination, American courts could not exercise jurisdiction over it or its crew, let alone its owners. In many instances, the law recognized that seizing the ship subject to post deprivation procedures represented the only adequate means of suppressing the offense or wrong or ensuring an indemnity to the injured party. And he goes on to say that justifying civil forfeiture in customs cases as necessary to secure such forfeited goods for the public use, though the offender himself had escaped the reach of justice. He goes on, but if history sanctions that line of thinking, it's hard not to wonder, how does any of that support the use of civil forfeiture in so many cases today, where the government can secure personal jurisdiction over the wrongdoer, and where seizing his property is not the only adequate means of addressing his offense? And how indeed. Now, notice here that Gorsuch's reasoning effectively disposes of both the main arguments advanced by the majority, both as to the precedents in $8,850 cash in von Neumann, as these are not, as he proves, dispositive precedents because both were customs cases, which are a special and distinct situation. And for that same reason, the founding era evidence cited by Kavanaugh is also inadequate because it too focuses on customs legislation. Now, more generally, if Gorsuch is right to conclude that a government seeking to deprive an individual of her property could do so only after a trial before a jury in which it, the government, and not the individual, bore the burden of proof, then the Alabama laws at issue in this case are clearly unconstitutional. A procedure under which the government can seize and hold onto property for many months before providing any kind of hearing clearly doesn't meet that standard. And this holds true for the way in which Alabama, like many other states, effectively shifts the burden of proof onto the property owner to prove that they are innocent of allegations against them. Now, Justice Sotomayor's dissenting opinion offers additional constitutional criticisms of the Alabama asset forfeiture system and others like it. Now, very much like Gorsuch, she also highlights the perverse incentives created by the current system, which allows law enforcement to profit from these seizures, and ways in which the system disproportionately burdens the poor and the disadvantaged, including property owners who don't have the resources for a prolonged legal battle. Losing the use of your car for many months may be only a moderate burden for the relatively affluent, but it's a much bigger one for a poor or working class person. And she also points out additional flaws in the majority's use of precedent. Now, from the standpoint of civil libertarians and property rights advocates, there is a clear silver lining to today's otherwise terrible decision in Culley, because at least five justices, as we discussed, seem very much open to issuing a broader ruling that would curb asset forfeiture. And in his concurring opinion, Justice Gorsuch comes close to just outright inviting litigants to file a broad challenge, arguing that most asset forfeiture requires a prior jury trial. And this is really beautifully written, in my opinion. He says, why does a nation so jealous of its liberties tolerate expansive new civil forfeiture practices that have led to egregious and well chronicled abuses? Perhaps it has something to do with the relative lack of power of those on whom the system preys. Perhaps government agencies' increasing dependence on forfeiture as a source of revenue is an important piece of the puzzle. But maybe, too, part of the reason lies closer to home. In this nation, the right to a jury trial before the government may take life, liberty, or property has always been the rule. Yes, he says, some exceptions exist, but perhaps it is past time for this court to examine more fully whether and to what degree contemporary civil forfeiture practices align with that rule and those exceptions. And ultimately, Justice Sotomayor's dissent suggests that the three liberal justices also seem open to the same sort of broader attack on at least the more egregious current asset forfeiture practices that are prevalent in so many states. And here, defense lawyers and public interest organizations should absolutely be taking note. And there should be people out there right now willing to take up Justice Gorsuch's thinly veiled invitation, because I believe that victory against unconstitutional asset forfeiture may yet be snatched from the jaws of this decision's defeat. Well, anyways, that's really all I have for you guys here today. Thank you so much for tuning in to Legalese. Now, if you would please take a moment and do all of those things that help to trigger Al Gore's rhythm, I would greatly appreciate it. If you like the video, go ahead and hit the like button. If you dislike the video and you want to be a dick about it, you can hit the dislike button. If you, subscribe to the channel so you know whenever I put out new content. And definitely leave me a comment. Let me know what you thought about the video. I do always love getting to hear your guys' thoughts on my videos in the comment section and interacting with you as much as possible. Until next time, this has been Bob for Legalese, talking about the beginning of the end of civil asset forfeiture. And of course, as always, Carthago delenda est.